Hello and welcome to Devil's Advocate. Has Judge Kode been fair to Sanjay Dutt? That's the key issue I shall explore today with India's former Solicitor General and former Attorney General, Soli Sorabjee. Mr. Sorabjee, let's start with the 6 years rigorous imprisonment sentence handed down to Sanjay Dutt. Given that he and his family did face threats, and given that the gun was never used, is it excessive or is it fair?
Well, the minimum sentence that could have been imposed is 5 years. Instead of 5, he gave 6. So if he gave 5, it would not have been excessive at all. Maybe 6 years, you might say so. And the question is not whether the family and the suffer stress. That's not the point. That doesn't come in when you give the mandatory period required by the section.
Except for the fact that this is rigorous imprisonment, not
That's
simple.
another point.
Why did the judge go for rigorous imprisonment?
Well, it is a discretion. The section penal code doesn't say, any section doesn't say there's imprisonment. But there's another section of the penal code, section 60, which says it can be rigorous in part, it can be simple in part, and maybe the judge could have done that.
So you think this is an area where the judge could have used his discretion and gone for simple instead?
I don't think it's an error, it's a question because the judge knows best, Karan. He's seen the whole nature of the case, the circumstances,
but in your opinion, you might have settled for simple.
If I were the judge, I would have settled simple for half the period, rigorous for the period.
What about something else? Many people say that Sanjay Dutt may be naive, he may be foolish, he may be rash and impetuous, but he's not a criminal. He's already served 16 months in jail. In those circumstances, 6 years rigorous imprisonment seems too harsh, it seems excessive.
I don't think so. Even if those circumstances were present, the imprisonment could not have been for a term of less than 5. That's clear. On rigorous, simple, we have discussed. It couldn't have been less than 5. The judge can't go against what the statute prescribes.
If public opinion widely believes that the sentencing is excessive and therefore unbalanced and unfair, would that not throw into question, first of all, its acceptability, and secondly, perhaps even raise question marks about its credibility?
Whose credibility?
The sentencing.
Public opinion, if it's misinformed, I would ignore it. Does the public opinion know that the minimum sentence is 5 years? It cannot be reduced then. Judge Kode would have been committed an illegality if we gave him 3.
So the only thing that can be questioned is the fact that it is rigorous rather than simple.
Yes.
That's all.
That's one thing you can.
All right,
there can be 2 views on that.
And you've indicated already that you perhaps would have inclined personally towards simple rather than rigorous.
No. No. Simple for some period, rigorous for another period, because Karan, this is not, he didn't have only a toy gun. He didn't have an air gun. This is a serious offense, so not as serious as other offense.
Let's then come to some of the legal points that have been raised. To begin with, Satish Manish Shinde, Sanjay Dutt's lawyer, has pointed out that even though all the TADA charges against Sanjay Dutt were dropped, the judge chose to refer to the fact that Sanjay had consorted at parties with criminal elements and to a characterization of the gun as a weapon of mass destruction whilst explaining the 6-year sentence. In other words, facts that had been left out of consideration at the stage of conviction were borne in mind at the time of sentencing. And Manish Shinde concludes that as a result, the judge misdirected himself and has ended up with a miscarriage of sentencing. How do you respond to that view?
Karan, to be quite frank, I've not read the judgment. I've not studied it. But if it is as Sanjay's counsel says as it is, and he's a very competent counsel, I would say that the prima facie, he has been acquitted of TADA charges doesn't mean he cannot take other circumstances into account as to how he came in possession. How did he come in possession? What did he try to do later on, trying to destroy the evidence that he had the guns? So these are the factors which he took into account, I suppose, for the purpose of determining whether there was a conviction possible under the Arms Act.
So what you're saying is that even though these facts weren't used for conviction, they could have been borne in mind at the stage of sentencing without the judge being guilty of either misdirection or mis-sentencing.
Yes, but as I said, I would not like to say anything definite about misdirection, not having studied the judgment. But prima facie, I don't think so. By the way, Sanjay is in one way fortunate. If he were convicted at TADA, there would have been great problems.
Absolutely. But the point is that since the TADA charges were dropped, is it fair that circumstances that would have applied to TADA should now be made to apply to the Arms Act for sentencing purposes only?
Well, I don't like to use the expression fair, because I think in a way the judge was a bit lenient towards him, the way he kept on adjourning the matter, not pronouncing the verdict, various other things. But I suppose in the ultimate analysis, what you can say is just look at the offense and then see whether this punishment of 6 years rigorous could not have been tempered with mercy.
All
but
right.
you may temper justice with mercy, but not by sentiment, not by what Bollywood says.
What about something else? Judge Kode, in explaining the 6 years rigorous imprisonment, also said that Sanjay was guilty of inducing others to commit a crime when he asked them to dispose of the gun. Now, is that fair? Because to begin with, all Sanjay did was to telephone from Mauritius. The people he spoke to were adults. They had the right to refuse. So where does inducement come into this?
Karan, let's not stress the word inducement.
But that's the word the judge used.
Maybe, but that's the English language is very, as you know.
But inducement is a specific word that suggests that you're goading someone in some manner.
Well, induce, suppose they're persuaded. Same thing. Why did he phone them?
But surely what he did was ask. They could have refused. If they had refused, he would have found another means. But they didn't. So in a sense, they willingly agreed.
But the fact that they willingly agreed doesn't detract from the fact he wanted them to destroy evidence.
But it does suggest that he didn't induce them to commit a crime.
Well, I don't know. You're just working on the word inducement. He did try. He did persuade. He did prevail over them. And they tried to do it, and they have suffered imprisonment.
All right. A second legal issue is to do with Judge Kode's refusal to grant Sanjay relief under the Probation of Offenders Act. Satish Manish Shinde points out that the judge erred in not calling for the probation officer's report because it was mandatory for him to do so. And secondly, he should have also examined the 4 witnesses the defense had provided.
Well, I don't want to join issue with Shinde. But as far as my reading of the Probation Offenders Act is concerned, I don't think it is mandatory for the judge to ask for a report.
So in fact, there was no erring in not doing so.
The fact that he did not ask for a report, I don't think is an illegality.
In considering the issue of probation, should the judge have borne in mind the fact that Sanjay has had a troubled childhood, that he's been a drug addict, that he's had 2 broken marriages, and yet he's pulled himself together, recreated his life, reformed himself, and now all of that could be at risk if he breaks in jail?
Actually, Karan, the 2 main considerations which should regulate judicial discretion in granting probation or not is the nature of the offense and the character of the accused. Now, these other factors, I will only ask myself one question. Suppose these factors were present even in the case of an ordinary person, Abdul Jalani, I'm just naming some person. Then we must be very careful that there should be no tilting of these factors one way or the other because Sanjay is a popular star, because Sanjay is a very important personality, because his wife, his sister is a member of parliament, they have Das Munshi and Kapil Sibal speaking out in the favor. Most important thing is no signal should go to the people that this is celebrity justice delivery system.
And if these factors that I mentioned had been borne in mind at the time of considering probation, you're worried that the wrong signals would have gone out?
No, wrong signals may have been gone up just because these are in the case of Sanjay. What I would really say
But just because Sanjay is a celebrity is not a reason to tilt the other way either.
Correct.
You seem to be suggesting that scrupulousness may have led to certain unfair treatment because things that could have been considered weren't considered for the wrong reason.
You raise a valid point. What I'm trying to say is what is really of importance is whole idea of the Probation Act is reformation. I'm with you, reformation.
And here, as I pointed out, there's a danger that a reformed man may break because he hasn't been granted benefit under the Probation Act.
But the whole question is his character for the last... So these are the 2 important incidents.
But the character I'm pointing out is that of a reformed man.
Yeah, but that past thing that he had a broken marriage and he was a drug addict and all that, to my mind, is irrelevant. How his behavior for the last so many months was a thing which is certainly important, and it is a very moot point whether in these circumstances he should or should not have been granted probation.
Ah, it's a moot point. In other words, it's a questionable and debatable issue.
Oh yes, of course it is.
Would you personally, if you'd been the judge, knowing the background of Sanjay, knowing the manner in which he's reformed himself, have granted probation?
I don't know how he's reformed himself. I wouldn't like to hazard an opinion because I knew his father very well, and when first Tata was challenged and appeared
But that
for him.
apart, be a judge, don't be a friend.
Yeah.
Would you have considered giving probate if you were the judge?
I would.
You would. Now, the prosecution have said that they are considering, in fact, appealing against the fact that Tata charges were dropped. If they do so, there's no doubt they have a right to, but would it be fair and would it be wise and justified?
I won't say that, Karan, because as I said, I don't know what are the grounds on which the Tata charges have been dropped. Look at it this way. Suppose they have been upheld in the case of others, and by the same reasoning or same evidence, they've been dropped the prosecution.
But there is an argument that's been made in some newspapers that if Zebu Nisa Qaidri as well as Mahmood Asar could have been convicted under TADA for either keeping or delivering AK-56 guns, then for Sanjay to be treated differently when the accusation is virtually the same is unfair. Does that, in a sense, make sense to you as an argument?
No. I don't think so, really. The judge must have seen the circumstances were different in those two cases. One thing is certain, that these were, as I said, not ordinary weapons, but did not use them.
What about something else? Sanjay's lawyers are going to go to the Supreme Court next week, maybe on Monday, maybe on Tuesday.
They may be right to do so.
What are the chances that, given the background, given what you said to me, that the court will either reduce the sentence or grant probate?
Probation?
Absolutely.
Best person to answer is Sanjay's lawyer.
But if you...
Because I do not know the facts.
You said a moment ago that if you
I would. I'm not sitting on the Supreme Court.
Given that Sanjay has already served 16 months in prison, I would reckon that somewhere at the end of the next 30 months, he would become eligible for remission of his 6-year sentence. Are those grounds for the Supreme Court to consider expeditious bail? Because otherwise, his appeal could become infructuous.
No, that's no doubt about it. And the Supreme Court will consider this bail application expeditiously. And I'm sure that these factors may be taken into account whilst deciding whether to grant him bail or not, or on what conditions.
So what you're saying to me, and I'm repeating because it's important, is that you can't comment on whether the Supreme Court will actually grant probation or whether the Supreme Court will reduce the sentence, but you do believe that the Supreme Court will consider and perhaps grant bail expeditiously.
Oh yes, expeditiously, and maybe, that's my hunch, they may take these factors and may lean in favor of granting him bail. But mind you, this media hype and all this can be counterproductive.
Absolutely, that was my last question to you.
It's not in favor of Sanjay is not doing himself any good. His friends are not doing him any good. In fact, people are getting put off by this. Why? Why all this in the case of one person? What happens to others who are rotting in jail?
Is there also a danger that what you call media hype might exercise such pressure on Supreme Court judges that to be scrupulous and show that they haven't in any way wilted, they may actually tilt the other way?
I think the Supreme Court judges by now are used to media hype, and I think they ignore it and they judge the matter according to the record and according to the provisions of law.
So it's public opinion that you're saying will get put off by media hype. It won't really affect the judges?
I don't think so. Our Supreme Court judges, I'm sure, don't get affected by this. It is very consciously.
Let's take a break at that point, Mr. Sorabjee. After the break, I want to talk to you about the political response to Sanjay's sentencing and the bigger, wider issue. Do we in India treat those accused of bomb blasts differently to those accused of riots? We'll be back in a moment's time. See you after the break. Welcome back to Devil's Advocate and an interview with India's former Solicitor General and former Attorney General, Soli Sorabjee. Mr. Sorabjee, let's come to the political response to the sentencing of Sanjay Dutt. Priyaranjan Das Munshi has gone on record to express his deep shock and surprise. He says that Sanjay's fault was only an unintentional fault, and then he adds that the time has come for civil society to gauge the parameters for an unintentional fault. Should a senior cabinet minister speak out in this way against a court ruling?
I think it's inappropriate. Especially as a senior cabinet minister, he may have his own views in the matter, but when he's expressing his views as a cabinet minister, he's actually questioning the correctness of the judgment. Now the judgment will be up in appeal. And I don't think it was appropriate. I won't say anything more than that.
What about something else? Priyaranjan Das Munshi has described Sanjay's fault as what he calls an unintentional fault. Now I ask you, what is an unintentional fault? Sanjay acquired the gun intentionally, he disposed of the gun intentionally, and as you know, ignorance is no defense of the law.
No, there's no question of unintentional here. There's no question about it. He got them, he knew what he was doing, he knew from whom he got. He knew he had the guns, and that's the reason he phoned from Mauritius, as you said, I didn't know, to get rid of them, whether induce, persuade, whatever.
So not only is speaking inappropriately and out of turn, but in addition, the concept that he's devised of an unintentional fault makes no sense.
Well, I think it was maybe off-the-cuff remark. That's a charitable explanation.
Let's come to a bigger, wider issue. Last week, 2 major bomb blast cases were completed by the courts. I'm referring to the Bombay bomb blast and the Coimbatore bomb blast. And yet the 92-93 Bombay riots have been treated very differently. In fact, just a few people indicted by the Sri Krishna Commission for those riots have actually been brought to justice. How do you view this disparity?
I think it's scandalous that the recommendations made by Sri Krishna report, Justice Sri Krishna, have not yet been fully implemented, and have not been pursued with the energy which they should. The matter has come up in the Supreme Court. At one stage I was there, but it was Government of India, and the Supreme Court told the state of Maharashtra that what are you doing about it? Then I don't know what happened. I got out of the case because I was out of office. But I think it must be because this also shatters the people's confidence in justice.
In fact, on that particular last point that you've made, do you get the feeling that India responds to those accused of bomb blasts very differently to the way it responds to those accused of riots?
No, I wouldn't say that, Karan. It is more about the personalities involved in Sri Krishna Commission report. I think that's the reason they don't want to really take action against the person indicted. So you're saying it's
politics rather than the differentiation between the two categories of accused?
I mean, riots also kill people. Bomb blasts, of course, bomb blasts affects the whole community. The whole of the bomb blast was to destabilize the country.
Let me for a moment interrupt you and tell you why I made that particular point. The vast majority of those accused of bomb blasts, particularly in the two cases that I've quoted, were Muslims. The large number of people accused of riots, particularly in the Bombay instance that I've quoted, are Hindus. Now, even if this may not be deliberate religious discrimination, will it not appear so to many of those who feel they've been denied justice?
I don't think, Karan, that's a fortuitous circumstance. The question is, you're not taking action against those people against whom action should be taken for serious offenses because they are high political personalities or they are for other reasons. I don't think it's really the question of Hindu or Muslim as such. I wouldn't even look at it that way. That's fortuitous. Question is, two things must not be mixed up. They are different. Law must be implemented fully, even-handedly in both the cases. If it's not done in the case of the riots, it's unfair. As I said, it's scandalous, and I think that the Supreme Court, I just read in the paper, I think they're seized of the matter. Mr. Yusuf Mushala has done excellent work bringing all these facts before the Supreme Court, and I hope the Supreme Court, and I'm sure the Supreme Court will give peremptory directions in this matter.
What about something else? It's also reported in the newspapers that of the 60 police officers indicted by the Sri Krishna Commission for their involvement in the riots, as well as the police officers who were identified by the Special Task Force for Punishment, only a small number have actually been punished. The rest have either been ignored or worse still, they've gone scot-free, or as you say, promoted.
Yeah, but that's why I use the expression scandalous. That has to be looked into.
But is it just scandalous? Will this sort of uneven treatment, in fact, this sort of discrimination, if I can use that word, not breed disillusionment, disenchantment, perhaps even dissent in Indian Muslims?
But Karan, this is not discrimination by the judiciary. This is discrimination in the sense, it's not that the court has said about those people, let them up. It is a fact that the political executive is not doing anything about it.
Absolutely. And the inefficiency, deliberate or otherwise, of the political executive to act, worse still, perhaps their culpable negligence, will it not breed disillusionment, disenchantment and dissent in Indian Muslims? Because they look at their politicians and say they behave very differently in one case and very differently when it affects us.
Well, it is they. The court...
The politicians.
Politicians.
And perhaps the police.
Maybe the police says, well, that's all right, but the whole question is now we should wait and see what happens after the matter is in the Supreme Court.
How long have we got to wait? We waited for perhaps as much as 16, 17 years. Surely patience must be running out for those who are crying out for justice.
Correct. But now that the Supreme Court is seized of the matter, I think they should not, they should wait and see what the outcome of the Supreme Court directions are, and I think that will restore their confidence.
So you're saying to those who are disenchanted and disillusioned, you've waited so long, wait just a little longer. The Supreme Court has taken matters in its hands. It's bound to produce results.
Yes, that's right.
Soli Sorabjee, a pleasure talking to you on Devil's Advocate.
Thank you.